The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Is the King of Pop's so-called reading library really a pornucopia of X-rated magazines? Hello, I'm James Curtis, and this is E's exclusive coverage of the Michael Jackson trial. Prosecutors turned to their version of CSI to prove that Jackson showed the accuser and the accuser's younger brother some very dirty magazines. On the stand, fingerprint analyst Lisa Himman drops a bombshell that the defense might not have seen coming. Under questioning by Assistant District Attorney Mag Nicola, here's what the witness told the jury according to the courtroom transcripts.
Can you explain what an inconclusive means?
It means it's a difficult print. And you can't rule the person to be a positive ID, and you can't rule him out to be a negative ID. With further time examining it and spending time running the ridges and working with the print, you can turn it into a positive and you can turn it into a negative. But at the time of the evaluation, at that time, we wanted to leave it as an inconclusive and come back to it because it was a more difficult print to make an idea of.
Okay, with respect to that particular print, an inconclusive fingerprint is one that you believe belongs to a particular person.
Objection leading.
I'll rephrase it, Your Honor. Did you have a belief as to who that fingerprint was made by, even when you labeled it inconclusive?
Yes.
Objection. Objection. That's an opinion without an adequate foundation.
It's overruled. She's already testified that she had an opinion separate from the other person, so I'll allow the question.
Yes.
And what was that?
As Star...
Well, next, were precautions taken to make sure that Jackson's dirty magazines would yield some clean results?
You mentioned something about separating items out of 317. Would you like me to get that out of the way?
That's fine there, yes.
Could you explain that for us, please?
I was asked to do a visual inspection of the contents, and I used an alternate light source which goes into the UV wavelengths. And when you look, search for body fluids, they will fluoresce under the UV light. And anything that seemed to fluoresce, it could be body fluids, but it could also be other things. My job was to find the items that weren't on the paper when they were published. They were placed there later. It could be anything that fluoresced. And I separated those items out for further testing. And when I did that, I repackaged them into another bag, and I sent them to the Department of Justice lab to find out what those fluids or deposits were.
How did you mark on a specific item where you suspected there may be some kind of body fluid or other substance that was foreign to the magazine or picture?
I sent the entire item to be re-inspected by the Department of Justice. I also put a yellow tab, a post-it note, on the page that I suspected, but I also requested that the Department of Justice reevaluate the entire magazine or piece of paper.
Okay, and did you keep a log of the items that you separated out of the briefcase?
Yes, I made a separate property form when I separated items out.
Do you recall which date you sent it to the Department of Justice?
On my report, I specify it as 2504.
Do you have a signed receipt?
Yes.
And what is indicated on the receipt?
2404.
Calls for hearsay.
2404.
Just overruled. Next question.
And how did you deliver the item to the Department of Justice?
I delivered it by hand. It came directly from our secure lab to their secure lab.
All right, Ricky Kleeman, this fluid's other indications that we don't know what it is yet, possibly, maybe. This seems a little sinister, but we haven't really gotten anywhere yet.
Well, it's a process. It's laying the foundation of where we're going to go. And what we find here, of course, is that we do have a print, inconclusive, which becomes conclusive, of Star. So at least we know that the accuser's brother had his hand on a dirty magazine. And so what?
That seems to support the defense theory, because I don't think that the prosecution is setting forth that Michael was trying to seduce Star. So the defense is suggesting, I think, that these boys got into these magazines themselves, and the fact that Star's fingerprints are on them supports that.
Exactly, and Howard, that's certainly where the defense is going, but thus far, what the prosecution is simply trying to say is the fingerprints of these kids, so far just Star, is on this magazine. We're probably looking toward, and we'll see if it materializes, Michael Jackson's print is also on the magazine along with one of the kids' prints.
Well, according to this witness, it's going to be whatever the prosecution determines. She says you can turn it into a positive or you can turn it into a negative. So let me see. It's inconclusive unless I'm working for the prosecutor
No.
and I want to. Ricky, this is what her testimony says, and if I cross-examined her, that's what she would
But isn't
end
that
up
a fair point, though, Ricky?
Wait. That's not at all what she means. What she says is she's got a print. They've run it. They haven't gotten to all the little ridges and whorls yet. We know it's a print. That is, there are sometimes you get something that you say you can't identify it at all. And then she gets the matches, and it matches to Star.
But what difference does it make? Timing is important. Yes, Michael Jackson perhaps looked at these magazines at some point. At some other point, these boys got into it. You said along with. The fingerprints were along with. We don't know
I said that. Let's be clear. Objection misstates the record. Let me be clear. What I said was that's what we would expect from the prosecution that they would show. We haven't seen it yet.
But they can't make that claim because, of course, you can't date the fingerprints.
But we do know that
we don't even know if we have both Michael Jackson's and one of the kids.
And that doesn't matter because the children simply say that these are where the magazines are. This is where you can find them, and at the time of the seizure, they're found.
All right. The debate will continue on cross-examination. Defense attorney Robert Singer brings up that old Aretha Franklin factor. Yes, that's a legal technical term. Chain of custody. Will explain it. Was it broken, though, dealing with this evidence?
So you would, based on your experience, you would say that the yellow seal represents
The original seal.
the sealing on November 18, 2003.
Yes.
And then you see at least one seal from later in November of 2003. Is that correct?
Yes.
So that implies or suggests to you, based on your training and experience, that somebody broke the yellow seal, opened the briefcase,
Yes.
and then resealed it.
Resealed it.
And how many other, or were there any others between then?
Yes, there's one other, 11404.
Okay, so on the 14th of January 2004, somebody else apparently did the same thing, which was at least open the briefcase and then reseal it.
Yes.
And you don't know what any of those people did with the contents of the briefcase during those two incidents between the original seizure and January 20th?
No.
All right, Sean, we've heard about this briefcase before. This is the briefcase that was testified to on our watch at least some days ago. Now we're to the contents of the briefcase. But doesn't Ricky have a valid point to this extent? Look, we're not really saying anything other than a corroboration, that is the prosecution isn't saying other than a corroboration of what these kids testified. We saw these magazines. No?
I say big deal. Michael Jackson has magazines.
Of course you say big deal. You're defense attorney.
No, Michael Jackson has magazines. Actually, I think that's a good thing for him. He's perhaps a healthy, middle-aged male.
Deal with the issue, counsel.
And we know that these kids have run wild at Neverland. They've gotten into things. I think we're going to hear testimony. They've gotten into the liquor cabinet, and they've gotten into the magazines.
Well, in fairness
big
now,
deal.
Howard,
They're
there have only been questions on cross-examination as to running wild. We haven't heard the affirmative evidence yet, right?
Is there any doubt that they were running wild?
They're children.
I don't think there's any doubt. And by the way, I don't think there's any doubt that someone could infer they got into these magazines on their own. I'm still waiting for some real evidence.
Absolutely. Now, Ricky, that is a valid point because as Sean said a moment ago, you can't place in time how old a fingerprint is, and even if we see ultimately that Michael Jackson's print is there along with one of the kids' prints, we don't know if they actually touched the magazines
at the same time
in the same place.
All of this is true. All I think the prosecution is doing here is really something very simple. They're saying, you want to attack my accuser? You want to attack my accuser's brother? You want to attack my accuser's sister? I'm going to show you little bits and pieces of evidence that make it appear as if their testimony is true. That's the prosecution's job.
Exactly. It's the prosecution's job.
It's kind of
and
the
let's
CSI
not forget,
syndrome.
Hold on a second.
That's the concern.
We'll deal with that when we come back. And let's not forget, a la Scott Peterson, when you have a circumstantial case, you got to put all those little pieces of circumstance together before you get to look at what the picture produces. When we return, a relentless cross-examination with some rather dramatic results. Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Science work or guesswork? Yes, I'm imitating Howard Weitzman. Defense attorney Robert Singer puts fingerprint analyst Lisa Hemman under his microscope. Here's what she told jurors during cross-examination according to the courtroom transcripts.
So fingerprint identification is really subjective. Is that correct?
Yes.
In other words, it's up to somebody who has training or whatever their background is to look at the latent and look at the rolled print and make a subjective determination that they believe that it's the same person. Is that right?
Yes, with training.
And we have indicated with a couple of examples, and I won't go into any more particular ones with you right now, but there have been a number of other notable misidentifications of prints in recent years, have there not?
Yes.
The materials in the briefcase are lawful to possess by an adult in California. Is that correct?
I believe so, yes.
Most of it's commercially available in one sense or another.
In one sense or another, I guess, yeah.
In other words, some of you can buy at a newsstand, others you might have to buy at a specialty store of some sort, but they're available, right?
Yes.
All right, all you armchair Johnny Cochrans out there, make a mental note. Subjective. Subjective is the watchword on that testimony. Here's what happened on redirect examination.
I'd like to show you Penal Code Section 313.1 and ask you to read it to yourself. Subparagraph A.
I'm sorry, is this to refresh recollection? If it's not, it's improper.
It's improper to read in court?
That's such a good straight line, there's got to be an answer, but I don't have one, Your Honor. It's not proper to have the witness read something unless there's a foundation laid refreshing recollection. She's being asked to read a law book.
I never heard that objection.
Have you read it?
Sort of.
Object, irrelevant. Have you read it? It's got to be relevant to something. Refreshing recollection.
It will be, Your Honor, and if it's not, the court won't let me ask the question, I'm certain.
The objection is overruled.
Okay.
Finished reading?
Yes.
Okay. Mr. Sanger elicited from you that the opinion possessing the kind of material that you found in the briefcase is generally lawful. You gave him the opinion that you thought it was.
Lawful to own by an adult.
If that material were shown to a minor?
I believe...
Objection, Your Honor. Calls for a legal conclusion.
It's rebuttal to your question, counsel.
It would be illegal.
You may answer.
It would be illegal to the minor.
And that's Penal Code Section...
313.1A.
Okay, I have one very simple question. Mom, turn the volume down. What the hell is going on in this courtroom?
I don't understand
We have
this.
got, let me just frame the issue for the sake of our viewers who aren't lawyers. What's going on here is a scientist reading the penal code in California. That's the book of laws that have to do with criminal conduct, even though criminal conduct is located in other books as laws. She's a scientist. Why is she reading a law book?
Well, she shouldn't be allowed to read the law book. Frankly, neither should a police officer be allowed to read the law book. This is really simple. First of all, we have to say Michael Jackson is not charged with showing adult material to a minor. That's not a charge. Even if we look at it as part of the fabric of the case, when you get to something like this, if the prosecution wants to say it's illegal for me to show little Johnny a dirty magazine, well, then the way to do it is the prosecution introduces the law for the judge to take what they call judicial notice. This is pretty amazing.
Now, Howard, let me take it in a slightly different direction. Even though this is highly out of the ordinary, highly unusual with respect to what's happening, what we just saw here, didn't nonetheless the defense open the proverbial door when he asked this scientist about whether or not it was lawful for Michael Jackson to possess this stuff?
Yes, it was a question I would have counseled him never to ask. But what bothers me the most, this is a question for the jury to decide whether conduct violated a particular section of the penal code.
And he's not even charged with that.
Yeah, that's correct. So you have a witness telling the jury what they're supposed to find when they consider the facts and the judge's instructions. I've never seen anything like this. And what else is disturbing? The judge seems to act like he doesn't understand what the problem is.
Right.
Sean?
Where's this guy
been? Exactly. I mean, the defense attorney is so confused, like, what's going on? And the judge is like, sit down, counsel. Yeah, this is what's going on.
We've all had those days in court.
Your Honor, I'm going to put you on the bench for just a second. How would you have handled it as the judge?
I would have said, what are you doing, counsel? This is completely improper.
Maybe call them up to the bench and have a little private conversation.
And all you say is, you just say to the prosecutor, if you intend to introduce this, is get me the copy of
By the way,
law.
Hold on. I got to leave it right there for a second. I got to get back into this piece of tape. Earlier, prosecutors called, this guy is so hard to control. They called the chief of forensics for, get this, the Secret Service. That's not a state of California agency, folks. This is a state of California case. The name Antonio Cantu to the witness stand, but in cross-examination, defense attorney Robert Singer tries to use this witness, of course, to his own advantage.
You certainly wouldn't want to take, for instance, a container with all the materials and take it to a grand jury and book it into evidence and then take it out months later and do fingerprints, would you?
Well, let me make a point here, if I may.
Before you make the point, is that what you would prefer to do or not?
Not necessarily.
Okay, you would prefer to do the fingerprint evaluation first, before you go book something into evidence before a body, whether it's a grand jury, a trial court, or anything else, right?
Yeah. You would expect to do the analysis first.
Okay, and were you aware that the fingerprint analysis in this case wasn't done for over a year after the items were seized?
Objection, argumentative, beyond scope.
Overruled.
Very well. First of all,
Were you aware of that, was the question, sir.
I was not aware that they were a year old.
Without belaboring this too much farther, there is such a thing as degradation of evidence, correct?
Yes.
And degradation basically means that over a passage of time, with or without other factors, evidence can degrade so that the ability to analyze that evidence becomes more difficult. Is that correct?
Not necessarily.
Excuse me. I didn't ask necessarily, so let me ask the question again so it's clear. Degradation involves something deteriorating over time, correct?
Yes.
Okay. And you're familiar with that in all sorts of areas of evidence besides, other than, let's say, fingerprints, correct?
Correct.
Okay. And degradation can take place because the underlying material on which the evidence is deposited starts to degrade, correct?
Correct.
Degradation can take place because there is, in fact, a chemical change in, we're talking about fingerprints, the actual fingerprints that are left on the item, correct?
Correct.
And just based on degradation, you can end up with a less clear, latent print than you might have had, say, a year before. Is that correct?
Again, I'd say not necessarily.
I didn't ask necessarily. I said you can...
Objection, he has answered the question.
I would like to...
Just a moment. Overruled.
I'm asking, is that something that's reasonably possible, that over a period of time, there can be degradation of a fingerprint, a latent fingerprint?
It is.
All right, second note for the day to all the would-be trial attorneys out there. The first one was subjective. The second one is degradation. We'll explain a little bit later. But can a little degradation or contamination change your fingerprints? That's what Assistant District Attorney Gordon Auchincloss wants to know.
Is contamination, any form of contamination, going to affect whether or not that fingerprint changes to look like someone else's fingerprint?
I'm going to object. The witness, it's beyond the scope of his professed expertise to do comparison.
This is not a comparison question. The question is chemical. Chemically based upon...
Excuse me, Your Honor, there's an objection pending?
I'm going to sustain the objection.
I'm sorry?
I'm sustaining the objection.
Okay. Can a fingerprint of one person morph into that of another person with a passage of time or contamination?
Objection, Your Honor. It's beyond the scope of his expertise.
He has stated that contamination is not within his area of expertise, counsel.
Is there any chemical process, irrespective of contamination, any physical process that you are aware of that will cause a fingerprint of one person to change and turn into that of another's?
Objection. Comparison is outside his scope.
I am asking him a chemical question. This is his area of expertise, the chemical formation of fingerprints.
I object to speaking...
Sustained. The question will be allowed.
Okay. Sir, chemically, I could only say that the chemicals of the fingerprint residue can possibly change. But as far as the pattern, I don't think so.
All right, Howard Weitzman, chomping at the bit is really an understatement for you today, young man. No more caffeine for you. We've got a couple of watchwords today.
Are you kidding me?
Yeah. Okay, I want to deal with three so we can get them all in right now. Possibly change. We saw that word with the psychologist about possibly could be lying when they're telling the truth with respect to kids. Degradation or contamination, and subjective. Let's deal with this degradation contamination issue first.
Well, I learned something this morning. I never knew there was such a thing as a chemical question. What a great concept. Of course, I have no idea what it means. Degradation, it can, it can't. deteriorate. It can't.
That means change, essentially. It
Yes.
can change.
Well,
and the
It
fingerprint
disappears,
change.
you know, over time. That's what they're trying to say.
But it
But
doesn't.
that would make the match more difficult.
Yes, but it still could make the match.
Which brings us back into now, Sean Chapman-Holly, to that first issue, that first watchword, subjective. If the fingerprint is deteriorating, if it's disappearing, to put it in simple parlance, does it make it one of those subjective problems? That is, it's up to whoever's looking at it. Beauty is in the eye of the beholder. It's a print, it ain't a print. It's a match, it ain't a match.
Right. And what also comes out, I think, in this testimony is, again, this witness's bias. His bias is so transparent. A very basic question is asked.
He's a cop, Sean.
I understand,
Of course.
but he won't even concede the slightest, most simple thing. Based on degradation, he's asking him a very simple question about degradation. He won't even answer that question. Well, not necessarily so. I'm not asking you
Well, but
necessarily
he
so.
does
I'm asking you to give a
Necessarily
basic
so.
answer,
Well,
and he won't give a basic answer.
Sean,
No, I
you're
can't be
such
that
a
harsh
defense
on him.
attorney. Go
I
ahead, Ricky.
can be. Yes, he can, because he ultimately gives it.
All right,
he ultimately gives
let
the
Ricky
answer.
have a turn.
But things do degrade, and you may or may not be able to make the match. That's
Yes,
all
exactly.
he's saying.
And he does, Sean, you must admit.
No.
Talking about hard to give up something and admit something, Sean. You must admit he does say that it's possible toward the
Finally,
end of this
toward the end,
examination.
finally.
Okay, we've got two people hard to control. We've got Sean joining Howard.
But I'm
Stay out of the
obedient.
gulag. When we return, will the trial start all over? I want to start all over right about now. And will comedian George Lopez, Jorge, as he was probably called in the hood, make a visit to Santa Maria? We'll be right back.
In the last few weeks, a large amount of ugly, malicious information has been released into the media about me. Apparently, this information was leaked through transcripts in a grand jury proceeding, where neither my lawyers nor I ever appeared.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. The big showdown happens on Monday, folks. That's when Judge Rodney Melville will hear arguments about whether to allow evidence concerning the, quote, other alleged victims of Michael Jackson, if there really are any. The outcome of the trial could certainly hinge on the judge's decision about that matter. Right now, to set that up for you, we're going to review some earlier testimony that, depending on how the judge rules about that matter, could have a huge impact. Last week, Kiki Fournier, Michael Jackson's former housekeeper, set off some fireworks of her own when she told jurors about the, quote, lost boys, end quote, of Neverland. Here's what happened, according to the courtroom transcripts.
Did he pick some kids over other kids to spend his time with and focus his attentions on?
Yes.
Do you remember any of their names?
Objection. Vague as to time.
Over your 10-year period?
Yes.
Relevance, foundation.
Overruled. You may answer.
Well, he had, some of his buddies were like Brett, Little Michael.
I'm going to object based on the court's ruling of 1108.
I can go to sidebar on this, Your Honor. We're not going any further than this.
I'll hold you to that.
All right, okay, go ahead.
Little Michael, his name was Omar. Frank, Aldo, I think Dominic. I get the two confused.
Is Dominic a as well?
Yes.
Is that one of Frank's brothers?
Yes.
Is Aldo one of Frank's brothers?
Yes.
Any other names?
Like Gavin was another person that he really took in. Macaulay. I can't really think of anybody else right now.
Do you know an individual by the name of Jimmy?
Yes.
Was he one of them?
Yes.
How about...
Yes.
All right, Ricky, with respect to what happened, changing gears, take a breath, changing gears from this compelling and riveting forensic testimony to one of the biggest issues in this trial, whether or not these other alleged victims will be in this courtroom, if not embodied, certainly in testimony.
Well, certainly it's the case. It is the case. If incidents come in concerning 1993, 1994, other accusers of Michael Jackson, the case is over for Michael Jackson because a juror is going to say, in essence, where there's smoke, there's fire. I also predict if it comes in, which we'll know about about, I think, on Monday, if the judge is actually going to rule on Monday, is then I say Michael Jackson does testify, because then he has nothing to lose.
Howard, you agree?
No. I don't agree. I think, as I've said all along, the train's on the track, and the judge may very well let this evidence in.
You think it's coming in no matter what, though?
Well, not no matter what. The judge could get a flash of sanity and act.
Now, Howard, be kind.
Let me finish. I'm being kind. Clearly, there's an issue as to the credibility of the alleged victims in 2002.
Sure.
The only way the prosecution, in my opinion, can bolster that up is to bring in another alleged victim. And by the way, are we going to try that case?
Yes.
How do you determine?
You mean these victims, 2003? These victims.
And the alleged victims in 1993.
Yeah.
And does the jury get to a reasonable doubt standard? How do you determine whether or not that alleged victim 10 years ago was telling the truth?
Those cases of these alleged victims, Sean, were never tried in court, and it is essentially a trial within a trial if it comes in, and the standard is not reasonable doubt for those other acts, is it?
And no, and that's why it's really going to be such a tragedy for Mr. Jackson and the defense in this case if it does come in.
Now, will it really, though? Because I'm not real sure, and I want to explore this some more. We're going to look at the cross-examination right now, because those other victims, I think certainly an argument can be made, have some problems of their own. I should say alleged victims. Now, the witness named some names that did not make Michael Jackson's defense team very happy at all. Defense attorney Sanger demanded that some drastic measures be taken.
What Mr. Auchincloss did specifically was not only ask a question to which a witness responded out of the blue, and named names. And I'll just avoid saying the names right now, but it's already in the record. And everybody will see it, I'm sure. But, you know, that can happen. You tell your witness there are certain rules, and the witness gets up on the stand and they're nervous, and all of a sudden you ask a question and they blurt out things that they're not supposed to say. That's not what happened here. What happened here was that the witness came up with one name, which was Macaulay, and Mr. Auchincloss, not being satisfied with that, went back directly to the very list of names that he has in his 1108 motion that he's been asking the court to be allowed to go into, and the court said no, not until we rule on it. He went down with leading questions, went down the list of people that the court has already indicated you can't get into until we have a hearing on it. So what do? As my former colleague in this case used to say, we have to do something more than nothing. And I think that's precisely what we have to do in this case. And I think the only proper remedy is to grant a mistrial. None of us, believe me, wants to sit here and start this case over again. But you can't unring the bell. They've gotten into specific names and specific allegations that they were told not to get into, and here we are.
Yeah, but what's in a name? District Attorney Tom Sneddon said the defense was making much ado about nothing. Howard, sorry about that Back to Shakespeare reference, but we'll try to tone it down in just a minute. Here it goes.
First of all, the court's 1108 motion dealt with specific allegations of misconduct on the part of the defendant involving other young boys. There was no attempt to elicit that information from these witnesses. There was no intent to infer that there was any improper conduct on the part of Mr. Jackson with the individuals. The questions were directed totally at the witness with regard to who were people who came to the ranch and visited Mr. Jackson on certain occasions. And frankly, given the court's ruling on staying away from the 1108 areas of misconduct, I can't see how, frankly, it comes within the purview of just simply asking whether these were individuals who came to the ranch during a particular point in time involving the period of time in which this person was an employee at the ranch.
To declare a mistrial or not to declare a mistrial, that is certainly the question. We'll have Her Honor, Judge Ricky Kleeman, give her perspective on that in just a little while. But for now, Judge Rodney Melville gave this answer.
One has to keep in mind that this isn't the first time that the jury's heard that name. And even one of the questionnaires for service of jury was to ask the jurors what they knew about the alleged 1993 or the 1993 alleged incident. And it's come up. 1993 has been mentioned by other witnesses. So it's not like this is the first, nor will it probably be the last time it's mentioned. So I'll deny the motion for mistrial and any request for sanctions.
All right, Judge Kleeman, what say you?
Well, Judge Kleeman, who has now been entertained with Shakespeare twice, says that the judge's ruling is correct. There is no mistrial going to be granted at this point in time. However, what I do also say is that although I am in the position of defending Mr. Sneddon on a regular basis, it is a bit disingenuous to say that we're just trying to show the context of who was here at the ranch. It just happens to be those particular boys.
Because what he's really trying to say is that Mr. Jackson had special kids. And here are the names of some of those special kids. And, of course, Gavin is one of those who he treated differently from the other kids who came to the ranch. That's the point of all
and the bell unringing argument, which we hear a lot, it really holds true here, doesn't it, Howard?
Well, first of all, the judge made the correct ruling, in my opinion, not granting the mistrial, but he has no control of his courtroom, or if he has control, he's allowing the prosecution to run wild. He should have said to Mr. Sneddon, look, clearly you put those names in for a particular purpose. Don't do it again. Remember what I said when this trial began, and adhere to those rules.
But, where was the defense attorney on their feet objecting to this testimony? When we return, the district attorney spells out exactly what he hopes to prove.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. For the last month, prosecutors have been up to bat, but are they hitting home runs or simply striking out? We're going to take a look back at District Attorney Tom Sneddon's opening statement so we can fill out our scorecard for the week. Here's what he told jurors on that very first day of trial, oh so many weeks ago. All this according to the courtroom transcripts.
This case is about the defendant. It's about his manipulation of the young boy's adolescence through exposing him to strange sexual behavior and introducing him to sexually graphic adult magazines. It's about how he traded on the boy's obvious and often expressed admiration for the defendant. And it's about how he exploited the knowledge of the fact that the child had no father in his life, and had no father in his life for over a year because of the separation and divorce of his parents and the fact that there was a court restraining order prohibiting the father from seeing the children. He exploited this paternal relationship and created another relationship with the child as a surrogate father, encouraging both the child, Gavin, the mother, and other members of the family to refer to him as Daddy or Michael Daddy. You will soon see, as one of the first witnesses in this case, the Martin Bashir documentary. You will see Bashir's probing and incredulous questioning of the defendant. And you will see the defendant's almost casual responses to his questions and trying to justify his admitted practice and long-standing custom and habit of sharing his bedroom and his bed with young boys. You see, the private world of Michael Jackson is quite different from what he said on that video. As the testimony and the evidence unfolds in this particular case, you will learn that the stories he refers to in that video remark do not consist of children's books, but the internet visits to sexually explicit sites, the exposure of children to suitcases, briefcases laden with sexually explicit magazines and centerfold cutouts from magazines such as Hustler and Playboy, with titles like Barely Legal Hardcore, Barely Legal, and many others with far more offensive covers and cover titles. You see, the private world of Michael Jackson reveals that instead of cookies and instead of milk, you can substitute wine, vodka, and bourbon. Now, publicly, Michael Jackson says he doesn't drink, but his private behavior and conduct is quite the opposite, as you will learn through numerous witnesses in this case. First, he's caught on film talking to Martin Bashir about wine, and he uses it and describes it as Jesus juice, the same exact expression that their children told detectives in this case that Michael Jackson used in referring to red wine that he provided to them, and he referred to it as Jesus juice.
Next, the elected district attorney's opening statement addresses the king of pop's cyber porn, but will jurors ever get to see it?
Now, what happens that night is this. The defendant, Frank Tyson, the defendant's children, particularly his son Prince Michael, and the two boys are in the downstairs area of the Jackson bedroom suite. And after a few hours, they go upstairs to the bedroom. And when they get up into the bedroom, Tyson pulls out a laptop computer. And Jackson and Tyson are hooking the computer up to the internet. And when they get on the internet, they then place the computer with the boys there, and they take the boys, 9-year-old and 10-year-old, on a tour of sexually explicit websites, naked ladies. They take them on a tour of a number of websites, and it lasts approximately 30 to 40 minutes. And during the time that they travel through these websites, at one of the points in time when a female is shown with her shirt up, exposing her breast, the defendant turns and exclaims, "Got milk?" And he turns around to the sleeping Prince on the bed and says, "Prince, you're missing a lot of." The boys spent the night with Michael Jackson. They did not sleep in bed with him. They slept in the bed. And it is true, Jackson slept on the floor.
All right, Sean, sum it up for us. Given what we heard in opening, now that our collective memories have been refreshed, how's it looking for the prosecution?
It's so difficult to tell how a jury is taking any of this.
That's true.
Clearly, we hear this, it sounds horrible. Yes, they've presented evidence that supports all of this. Clearly they have. But we've also seen on cross-examination that the witnesses' credibility has been undermined. It's impossible to know how the jury's taking it.
It's impossible to know how effective it is, but Howard, I think we all must concede, effective or not, convincing or not, that Tom Sneddon thus far has been able to prove up in this courtroom what he said he would prove in opening statement.
Some of what he said he would prove.
Some of it.
What we just heard, I didn't hear any criminal conduct described in these statements.
Well, this is just one section.
I understand that, but now I'm just taking this because you asked Sean about it. I haven't heard any criminal conduct.
Yeah, but
here.
come on, Howard, that's not the question. The question and
James,
issue here
is the question.
Well, no, but
the issue
is this is what the DA said he was going to prove.
Yes.
The significance, weight versus admissibility, counsel. No.
Well, here's what I think is important. When you read some of the viewers' emails, it's like myself and Sean in particular are apologists or defenders of Michael Jackson. Here's the reality. If he's good, as you said, for this crime, he ought to be convicted and he ought to pay for it. I've been in the system almost 40 years. Yes, I'm a bit of a cynic. I want to see credible evidence. If credible evidence is produced and it's believable, I'd be one of the first people to say this is somebody who deserves to be convicted and punished appropriately.
Sure, I understand that.
Can I just say quickly for the prosecution's point of view, I think that when we look back to Mr. Sneddon's opening statement, that it even is richer and more nuanced than I thought it was when I heard it in the first place. Yeah. And what we see is the private world versus the public self. And that is a very important image for this prosecutor that lasts with this jury.
Absolutely, and even though Howard Weitzman doesn't like it, it does provide some significant context. Don't look at me like that, Howard. Next, here's what the district attorney claimed that we'd hear from the accuser and his younger brother, as well as his sister. The question for you and for us, we heard from them, but is this what they said?
The private world of Michael Jackson reveals that instead of bedtime discussions and children's books and discussions of Peter Pan, at the same time that this 44-year-old man is sharing with 13-year-old Gavin and 12-year-old Star and another 11-year-old boy his collection of sexually explicit magazines, that he's talking to Gavin about masturbation. And he's telling him that it's normal, that it's okay, and that everybody does it. That each of these acts are calculated to desensitize the boy, to change his moral antenna, and to add the trust and the admiration of an adult voice to the boy's conduct, to convince him that what was being done was all right in the adult world. And it worked. Lastly, you're going to be able to peek into the defendant's private world, and you're going to hear Gavin describe to you his molestation. You will hear Star tell you how, on other occasions, he happened upon seeing Michael Jackson masturbating himself with one hand, while Jackson's other hand was inserted into the underpants of his brother Gavin.
Now, Ricky, with respect to Tom Sneddon, he's the elected DA. He's tried a lot of cases. According to his office, some 500 to 600 cases. He's tried some sexual assault cases, but from what I can tell of his record, he's a bit rusty. He's only tried maybe one case, even though it was a long one, over the last couple of years.
It's all right. I bet you and I could go in after not having tried cases because we're doing TV commentary, and we would be just as solid as we used to be.
Well, and is that what's happening here? Are we seeing
I think he's solid. I do. I think that some people may not like him. Some people may call him overzealous. But I say this. His opening is solid. When he works with these witnesses, I think that the witnesses are as vulnerable as the witnesses are. It's not his fault. And I
You don't get to pick your witnesses.
You don't. You don't get to pick people who become victims of child molestation if in fact they are, and those people tend to be vulnerable and troubled. In this particular example, what we find here is he tells this story, which is told again by his own expert, of how you desensitize these children, how you seduce them.
Yes.
And that's what he's proven up if you believe the kids.
If you believe the kids, but Howard, one of the things and the distinction between an opening statement and a closing argument is that there's not supposed to be any advocacy. You have to believe I'm right in the opening statement. But there is a little bit here. Where's the defense attorney jumping up saying, objection, this is not argument, this is opening statement?
Well, I think the defense attorney has a good idea of what the judge will do, and he doesn't want to make it look in front of the jury like he's interrupting Mr. Sneddon. This is, for the most part, an appropriate opening statement. This is what he says he's going to prove. Ricky, an actress at heart and in real life, by the way.
Oh, ouch.
Correctly indicates you try to paint a picture, you try to set the mood. That's the arc, you know, beginning, middle, and end.
Yes.
And that's what he's trying to do here, and he's done a halfway decent job. However, it all depends on the witnesses and if they're believable or not.
And it's not so impressive for a DA to say, this is what I'm going to show, and then be able to show it, to say the expert's going to say this, and then he knows the expert's going to come in and say that.
These defense attorneys
Big deal.
talk
That's
about
what you're supposed to do as the
willing
DA.
to give the DA just a little bit of credit. When we return, today's Big Shocker. Stay with us.
I am not guilty of these allegations, but if I am guilty of anything, it is of giving all that I have to give to help children all over the world.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Here's a riddle. Can you still call something a surprising twist if we're expecting surprising twists every day? Well, this bit of news may have surprised defense attorney Tom Mesereau, surprised us a little bit. Here's what happened according to the courtroom transcripts.
I just wanted to notify the court we were able to resolve one of the issues that was pending before the court. Over the last break, I spoke with Mr. George Blancart, who is George Lopez's attorney, and we are agreeing they are withdrawing their opposition to the subpoena that had been issued by the defense. In fact, Mr. Lopez will be testifying for the prosecution, we expect on Monday.
Here we go, folks. George Lopez.
Way cool, I say.
What the heck is he going to testify? All we've heard so far is that the dad thought he stole some money from the kid. How does that help the prosecution? What's he
I
gonna
don't know,
say?
but you know, it seems to me a bit of posturing by the prosecution to let the defense know we'll be bringing Mr. Lopez in on Monday. You thought he was your witness. He's our
Yeah, but fair enough.
witness.
But what's he going to say?
I don't know.
What he's going to say is probably the story that we expect him to say. This is the issue that you have been telling the prosecution to do for these many weeks. Take the wind out of the defense sails. Don't let the defense do this. Do it first as the prosecutor. And I bet what happens, let's assume the story is correct about the grifting of the $300 in the wallet. It's not a grift from Mom.
Exactly.
It's a grift from Dad.
That was the only thing I could think about, Howard. It's going to be testimony along the lines, looking into our crystal ball. It's bad dad, not bad mom or bad kid. What do you think?
Honestly, I don't get it. I hope George Lopez will be entertaining as he is when he's working, because if I'm the prosecution, I think they made a bigger issue out of an issue that's not that big. George Lopez, by him testifying, they could open the door for all kinds of fruitful cross-examination. If it was me, I wouldn't have taken the chance.
And certainly, Sean, you have to agree that this idea, this story that George Lopez was accused by Dad of taking money is not good for the prosecution.
No, it's not good for the prosecution. And I continue to say it's not bad for the defense that it's the dad and the mom. Notwithstanding the fact that Mesereau puts it all on the mom in his opening, still, it makes for a not believable kid or kids if you've got two parents.
But dad's out of the picture when these allegations happen.
But does that spill over on the whole family? Well, that's it for
Yes,
today. Be sure to watch our exclusive Michael Jackson coverage with Howard Weitzman, 10 a.m. tomorrow and 4 p.m. right here on E! You guys are on fire today.